Hey, aspiring estate planners, 15-year estate planning veteran, wealth transfer coach, Steve Gibbs here. Today's topic is what component parts, namely documents, need to come together in a synergistic way in order to have what we call a complete estate plan. And the related question, why a will is really not enough to get complete protection for your loved ones. Most estate lawyers know this extremely well, and by the end of this video, you're going to know it very well. You're going to know the different component part documents that you need to have, and you're going to get some really good insight as to how these documents can work together in order to make sure that you have complete protection around your plan. First question, why is a basic will not enough? And the short answer is that a basic will is really an instruction sheet for the probate court. So I'm just gonna instruction sheet, court, and judge, which is good, right? And you want the court to have instructions, and this is why everyone says, well, you should have a will. Well, if you're not going to have anything, you're better off having a will, because otherwise the state will end up deciding what happens to your assets, who gets what. So in and of itself, a will is important. However, wills lead to war stories because they don't prevent any kind of contest. They lend themselves to contests because they're already in court. I've got a lot of war stories. I'll share one in particular I heard recently. This is a guy who went and got himself a will, and he forgot about it. Ended up actually running off to Vegas with a gal a couple years later, got married, which sometimes, guys get married later in life. This is a second marriage for him. Ended up dying a couple years later, didn't do any additional planning. And that was when the party began for the courts and for the attorneys, because a massive battle ensued between his surviving spouse and his heirs, which again often does happen with second marriages. This was a battle that lasted over 9 years, and the probate court fees surpassed $3 million. The initial deposit on the court fees was over $1 million. So actually, my mother-in-law had another situation. This was long before my time with her. Had a 6-year court battle due to probate and ended up with a fractured relationship that to this day hasn't recovered. So this is why the will-only plan is no bueno. So what do you really need to have a complete estate plan? You're going to need a number of other documents, and I could do a separate video on each one of these documents. But what I want you to get is just a snapshot of each. I want you to know what each one of these documents can do and how they interrelate together. And so the first document that could have avoided this entire 9-year court battle would have been a living trust. All right, the living trust, you've heard of it probably, or maybe you've heard of it referred to as a revocable trust. What this would have done is it would have taken the entire estate in our example, or in both of my examples, away from the probate court and put them in a private administrative process run by a trustee. Trustee is somebody that you would appoint, so it can be an individual family member. It could be maybe for a larger estate, it could be a corporate trustee. It could be co-trustees, so with a larger estate, it could be a individual plus a corporate trustee working together. Could be two of the siblings, for example. It's a matter of choice, and what this does is it creates a private administrative process for the estate as opposed to the public probate process. And in some states, you have the ability to do a no contest clause with it. At the very least, you're able to make provisions for different people. In our example, he could have made a lifetime provision for his surviving spouse, could have had the remainder going to the heirs. And what this does is it creates more confidence within the family as to this being the exact intent of the deceased person. This oftentimes is much less clear. So the revocable living trust, with those parameters in place and properly funded, it has to be properly done in order to do what it's intended to do, which is avoid probate and create this private process. The next thing that could have been beneficial or would have been beneficial would be the pour-over will. So this kind of a will is a different animal from this one because a pour-over will is designed to capture assets that aren't titled in the trust and basically put them in the trust. An example of this would be our guy, say he bought some real estate or bought some other investments but never titled them into the trust, never funded them into the trust. The pour-over will would have captured the assets at death and put them into the trust so that then they could be administered, as I just said, by the trustee in the private family process that I mentioned. And this is a simplified probate, so it's not the same kind of a deal here where all these assets are being distributed. This simplified probate is pretty one-dimensional. It's just designed to put all the assets in the trust. Next thing that they could have benefited from would be a durable power of attorney. I'm going to call it POA, but it's a power of attorney. So what this is, it's a life document. This is a document that could have given somebody the ability to modify the estate plan prior to this gentleman's death. These do expire upon death. However, let's say some accommodation needed to be made for the surviving spouse. That could have been memorialized either in a trust created by the power of attorney or updated prior to death, or even just the will could have been updated to provide some kind of specific distribution that could have avoided the entire conflict. So the durable power of attorney is very important. It goes hand in hand with these other documents because it can amend these documents or otherwise do administration that's needed. All right, healthcare. If you're around my age, you might be familiar with the Terry Schiavo case. That was a case that erupted due to the litigation that ensued between a husband and her family, a wife's family, over the removal of life-saving treatment. This is another area where things erupt into very expensive legal controversies, and this could have been avoided by a simple, what we call a living will, which is part of this, and then you also have a designated person designed to make decisions. Some people call that a healthcare power of attorney. In some states, call it a healthcare surrogate. Okay, so you have to make those appointments, avoiding costly litigation. Final instructions. As morbid as it sounds, I personally observed major controversies erupt over final disposition. In other words, somebody wants to cremate a family member and others want burial for maybe religious reasons, or reasons of faith. So final instructions is another way to avoid costly breakdowns among family members. Finally, we want asset lists. Assets lists. That can include a list that goes along with the trust that tells everybody the assets that went into this trust so they don't have to do as much detective work to figure it out. Could be a personal property memorandum that's also linked. Sometimes this will or the trust itself will refer to a personal property memorandum, which basically says who gets what personal property. Imagine the difference when you have a list of items that are going to specific people, or you have no list, no anything, and you have people fighting over things, and you have all the relationship strain and stress that goes along with that, which I've observed too many times. So these are the component parts. I just told you why this isn't going to be adequate for a complete plan, and you have these various component parts that you can put in place that you want them to synergistically work together. You don't want them to contradict one another in order to formulate a complete protective estate plan. If you're looking for action steps, there's going to be a link wherever you're watching this, and we do have a learning center. You can go there. There's going to be an interactive map that you can actually click on your home state. Home state's important when you're putting together any of these documents because these are creatures of state law. So Idaho might be different from Texas, Florida, etc. Each state has its own things. You can look at your home state on the interactive map. You can pick up a free ebook on the website. We have a lot of education there. Also want you to feel free to leave a comment. If you have questions, I'm happy to answer the comments. And if you have a probate war story, leave it there, because that can be helpful to our audience to know that this is a high stakes game. This is not minor stuff. People are grieving. There's lots of money involved. And so having this very clear is a huge lifesaver for loved ones down the road. And with that, I appreciate you watching, and I'm going to see you in the next one. Thank you.